Good morning, everybody, or good afternoon, wherever you are today. Thanks for joining us for Up in Smoke, the Cannabis, Insolvency, and Corporate Reorganization webinar we're hosting today. My name is Hillary Bricken. I'm a partner at Husch Blackwell. I'm on the cannabis, corporate, M&A, and security side. And before we begin, I just want to cover some housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during today's program. If you have any questions during the webinar, please feel free to ask them and submit them via your question box. We'll try to get to what we can today, and if a fuller answer is needed, we will do our best to try to answer it via email after the fact. And feel free to use reactions during today's webinar. Those are helpful to us to understand that you're listening, and if you've got any additional questions, you can react by clicking the heart icon and selecting one of the options there. Toward the end of the program, if you don't mind, please be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. And finally, a recording of the webcast will be emailed to everybody in attendance tomorrow for watching and sharing. So without further ado, let's get to our program. Today, joining me, I have a great panel around this pretty obscure and difficult topic of cannabis insolvency, given that cannabis remains federally illegal. We have Steve Ham, who is the co-founder and managing partner of Altmore Capital Investment Management. We have Eric Morcheski, who is the CEO of Nimble Strategies, and will be talking to us specifically about receiverships. We have Michael Brandis, who is my colleague and partner at Husch Blackwell in our Chicago office, who is an insolvency lawyer. And finally, Brent Salmons, who is an M&A corporate securities partner, who's also done a lot of cannabis deals over the years out of our DC office with Husch Blackwell. So this is going to be a roundtable discussion, and if attendees have questions, like we said, please feel free to ask them. We'll pick them up if and as we can as they come up. But what I want to do actually is start with Steve, and I had planned to do this because we got some exciting news this week, unless you've been living under a rock, that the DEA will eventually reschedule cannabis to a Schedule III drug. Now, that's outside the scope of this conversation, but I can only imagine the impact it's going to have in the cannabis market overall. So the first question here today is for Steve Ham. What's the market looking like as a lender in the cannabis space? Because Altmore is a pretty big player when it comes to lending to cannabis companies.
Yeah, glad to be here. Thank you for taking the time to join us. The last 3 or 4 days have been pretty interesting and exciting at the same time. We've been inundated with calls from different potential investors as well as existing investors, really trying to peel back the implications and the different impact it's going to have on our industry as well as how we invest. I think it's overall a very, very positive event for us. I think probably the most impactful thing that's going to have for the industry really is the repeal of 280E. What that really means for operating companies as well as the companies that we lend to is that there's going to be a lot more cash for the companies to invest back into their operations, as well as perhaps also they can leverage more, given the fact that there's more cash flow in the businesses. So this is really a great day for the industry overall. And as an indirect result, the valuation of these companies are going to go up. So that also unlocks the opportunities for these companies to raise equity at a higher valuation. And that's going to be a great thing for all the equity investors as well as debt investors going forward.
And I just want to remind our attendees, unless and until we get an interim or a final rule from the DEA, which their proposal is currently in front of the OMB, that's part of the executive branch, they have 90 days to evaluate it for a variety of things. The status quo remains, which is honestly the point of this webinar, in that hundreds of cannabis companies are in great distress because revenue has been flat because of issues like IRC, 280E, the inability to take normal business deductions because this remains a Schedule I controlled substance. So I'm glad the outlook is positive. And especially as a lender, the other things I want to discuss, and I'm sure this will stoke some conversation among the panel, when you're looking for cannabis targets, and I don't mean in the future when valuations are more realistic, healthier, and there's more money to go around all the way because of 280E relief alone, what are the green flags that you look for in your targets, and what are the red flags? And I imagine over the past couple of years, there have been more red flags happening than green.
Yeah, so we typically invest into already cash flowing businesses. So we obviously look for companies that are already in operations, really at the lower end, generating about $30 million of EBITDA, all the way up to $250 million in EBITDA. I'm sorry, 30 million in revenues, and all the way up to $250 million in revenues. Um, Really, but at the end of the day, where rubber meets the road is the management team there to really shepherd the business going forward. And this is a very dynamic, topsy-turvy sometimes, very, you know, uh, almost sometimes too dynamic for a lot of the management team. And because this is a very nascent industry, there isn't the management depth as some other industries I've been in the past. So really picking that right management team to really be able to navigate the ups and downs of the industry is really, really important to us. So it's like the old adage in real estate: location, location, location. For us, it's management, management, management. And then secondarily, it's the regulatory regime that the operators operate in. So some states have much more favorable regulatory regime versus some others, that allows the operators to have perhaps less competition than some others, and that certainly helps in managing the business. So those two things kind of come to mind right away. With regard to some red flags, you know, again, we don't really invest into startups, so that's certainly not a place where we look for deals often, although there are some exceptions. Also, thin equity cap is typically not a great place for us to look for deals. We want skin in the game from not only the management team but also the equity staff that's below us. So we want to we want to make sure that everybody's in this together. We're committed to supporting the business and many times ups and downs of the growth cycle. So we want to see great management team, good equity stack that's going to support the management team, and obviously we can layer on top of that our growth capital to get them to the next level of growth.
And I got to ask this because I've been in the space practicing for a decade plus, and I know in my conference room, I think I've had the best grower in the world dozens of times,
Yep.
according to them. So when you're looking at operational teams, does it matter to you that there be somebody maybe in the C-suite or in a management capacity that's got those legacy chops anymore? Does that matter?
To be honest with you, like it is if you peel back the kind of the veneer of the cannabis company, this is really a CPG company at the end of the day, right? So what we rely on is really the data, especially on the upstream side of the business where cultivation and manufacturing companies are concerned. We rely on data more than anything to judge the management team, right? So when it comes to cultivation, really the efficiency of the operators to really squeeze out as much efficiency out of the capacity of the cultivation. So, for example, grams per square foot is one of the benchmarks that we judge. We used to judge the performance of that particular operator. So we see typically 60 grams per square foot, all the way up to 100 grams per square foot. So if you're landing somewhere in that zone, I think they're a very competent grower and cultivator. but anything below that is subscale and not efficient. So again, it's all about the data, and as you asked in an earlier question, what are the red flags? If the management team doesn't already have these benchmarks laid out to really judge how they're doing in their efficiency of running the business, that's certainly a red flag.
Okay. And then small follow-up, just because I think our audience would like to know, I always want to know this. What's been the best state for you so far, and the weakest state, if you can give us that perspective, because it is a patchwork quilt of regulation. It's a lot like liquor. Whereas you said certain states are very business friendly, some are limited license, some it's a free for all with a ton of diversion and you wouldn't want to touch it with a 10-foot pole. So what's worked for Altmore on the state by state side?
Yeah, Missouri, I have to say, has been a great state for us. So the same goes for Maryland. Those two really, as a result of kind of the regulatory regime, has been really, really outstanding. There are a couple of states on the other side of the spectrum. Oregon's been a difficult state, so we haven't, we haven't invested into that state at all. Washington is a bit of a interesting story because depending on where you are on the supply chain, it can be either good or bad, right? So if you're on the retail side of the Washington state, you're going to do okay. Whereas if you're on the cultivation side, that's going to be a very difficult state. So, when you look at cannabis investing, you really have to dive into each state to see if that's going to allow you to have that, slight advantage in your investing. So it's not a nationwide thing. It's really a state by state, and then once you go into retail, it really becomes county by county type of diligence. So it does become fairly complex, but at the same time, that's what makes investing in cannabis pretty exciting.
Now, given the current federal illegality, which again will remain and may still remain even after we get a final rule from the DEA on the back of this announcement, how aggressive is Altmore, if you can share, in its relationships with these borrowers, these investment targets? And this is on the back of almost all of these companies being unable to access financial institutions for anything more than depository accounts because of money laundering and violating the Bank Secrecy Act. And it plays into our topic today of insolvency for when things go wrong and folks default and materially breach, and how we resolve those. So how aggressive are you?
So, it's a great question. So the way we actually approach our borrowers, we don't even call them our borrowers internally. Like, so when we speak internally about our borrowers, we really refer to them as partners. And the reason we do that is we do get substantial equity as part of our investment as well. So we do have obviously some incentive to be as cooperative as well as supportive to our partners that we lend money to. So, the first thing that we do is we try to resolve any kind of pear-shaped events through communication and, as I referred to before, the equity stack that's below us. So we resolve vast majority, if not more than vast majority, of any kind of defaults or any kind of situations with the management team and the equity. That's really our first and foremost way to resolve any kind of issues. Now, not all situations can be resolved that way, right? So there are some systematic issues within the company as well as the cap stack that we do have to resort to different types of workout situations. But that's what the great law firm like Husch Blackwell is there to help us through, right? So, aggressive isn't really the word that I would use. It's really, running through the process of resolving the situation, and then run through that process, and then if there's no other issue or no other options to kind of get to the other side of the restructuring, then we'll have to kind of resort to uh, call it ABC or other types of restructuring processes.
Got it. Okay. I'm going to shift the dialogue over to Michael, who, if you're speaking to Michael, you might be distressed in running your business, but that is not necessarily a bad thing because Michael is there to help on restructuring and insolvency. So, Michael, you and I and Brent have been dealing with a lot of this lately. It seems like some large scale ones and smaller ones, but there's a demand for knowledge here about when things do go wrong with operations and finances. What relief do cannabis companies realistically have in front of them? And again, because of the current federal conflict, which may or may not change here imminently, is bankruptcy available to these businesses at this point in time? Because there has been some case law that's kind of shifting depending on where you're at in the country. But why don't you share with us the current landscape of being able to access federal courts for bankruptcy relief for cannabis businesses, direct or indirect?
Yeah, no problem. And so thanks, Hillary. And thank you to our audience for being here today. When a company in general, forget cannabis for a second, when a company knocks on the door to an insolvency attorney and says, I'm having trouble, the options at that point are inherently limited. Cannabis companies, even more so, because to answer your question more directly, bankruptcy is not currently a viable option for cannabis-specific businesses. So those businesses that are actually a cannabis business. Now, there's some nuance to that issue. The Hacienda bankruptcy case, an opinion was just entered in the Ninth Circuit, in the Ninth Circuit Bankruptcy Court, which allowed for a business that had previously been in the cannabis business to go through a restructuring. There's also other businesses I've been involved with, a soil producer that only client was in the cannabis space, was able to reorganize through Chapter 11. And so under that scenario, bankruptcy was available. But a company that is specifically in the cannabis space, cultivation, dispensary, they cannot file for bankruptcy. It's just not available to them at this point. Did you want me to go into some of the alternatives?
Not yet, because we just got our first audience question. And this is, I mean, fair enough. It's totally speculative, but it's a great question. Will this rescheduling from a 1, which is totally off limits, no medicinal value, completely illegal, highly subject to abuse, even with medical oversight, and big no-no, to a 3, which is much less restrictive, although is still going to have some guardrails? Do you think this is going to change the ability to access bankruptcy courts for these state legal cannabis businesses? I have my own theory on that, not necessarily from a bankruptcy perspective, but from a state versus federal law perspective. But what's your take? Do you have a take yet? It's been like 30 seconds since this was announced.
I do have a take.
Great.
And that take is going to be based very much on where the first cases are filed. And so the Ninth Circuit's going to be more liberal. Other circuits in the country may not be. Generally speaking, a criminal enterprise is still a criminal enterprise. I don't think that the federal government is necessarily going to distinguish between the different schedules. If the federal government still deems it illegal, then they're going to prohibit a bankruptcy plan or a bankruptcy filing in which a cannabis-specific business, I know I keep using that term, but a business that's dealing specifically with cannabis and not adjacent to it, I don't think bankruptcy will be a viable option even after the rescheduling. However, the Ninth Circuit, the California courts, and some of their neighboring states have been far more aggressive in pushing the boundaries than states that are further in the middle of the country or further east.
Yeah, and I think we should emphasize to everybody listening, and this news is very new, but the impact is not, this does not legalize these state licensed cannabis businesses in any given way. They will remain federally illegal, even as Schedule 3 is on the horizon, because unless they register with the DEA, have FDA approved GMP facilities, go through a pharmacist and a licensed physician through prescription, they will still violate federal law, just not on the Schedule 1 level. So I can imagine it's still going to be hairy from a bankruptcy perspective in liquidating what are still federally illegal assets as far as the court's concerned. But let's move on from that. What are the alternatives to bankruptcy that are being explored now. And this seems to be really kind of the Wild West between these two areas, this cannabis regulatory emerging nascent industry and some obscure choices in lieu of bankruptcy.
That's right. And I just want to sort of add on to something Steve was saying. When they look for good management teams likewise should look for good lenders. And the reason is because when things do get hairy, it's important that your deal partners are collaborative and that you're working together to find a solution that preserves the value of these companies, because in many instances, the license is the most important asset. And there are certain ways to essentially screw it up in the process. And so finding ways to navigate those regulatory issues on a state-by-state basis is an important consideration. But, speaking categorically, there are receiverships in certain states that are a viable path towards, and I know Eric's going to speak to that shortly, but receiverships provide sort of a viable path to, in many distressed situation. There are assignments for the benefit of creditors that's available in certain states, I believe 26, primarily in California and Illinois, where it's extrajudicial, and then Florida. And that scenario, I don't want to speak over anyone's head, is one, and I should speak to receiverships too. A receiver is where a court-appointed intermediary comes in and takes control of the business. Depending on the state laws, and in California, they're really well baked out, in other states, maybe not so. The receiver will have certain rights to administer the business and shepherd it through potentially a sale, depending on what the receivership order provides. An ABC is totally out of court in many instances, in Illinois and California in particular. In places like Florida or Minnesota, it's actually in court, similar to a receivership. But you assign all the assets of a company to a third-party trustee. It's similar to a receivership. I consider it in many instances a cheaper alternative, especially in California and Illinois. And it's out of court. And that trustee intermediary then finds a way to liquidate the assets. They can run the company as a going concern, assuming they get the necessary regulatory approvals, and then they can sell cultivation, dispensary, whatever it may be, to a prospective buyer. So that's a possibility. There's also other alternatives, foreclosures, deed in lieu of foreclosure. Canadian bankruptcy is an interesting thing because a Canadian bankruptcy where there are U.S. assets, basically what happens in our U.S. bankruptcy law when there's a foreign bankruptcy is that in a standard context, non-cannabis, the proceeding is recognized through what's called a Chapter 15 in the U.S. And so a company that files for insolvency in Canada or the UK or wherever it may be will file this recognition proceeding. In the US, again, the bankruptcy courts really aren't inclined to touch it. They're just not going to have a Chapter 15 concerning assets that are federally illegal. So there's really questions about the applicability of a Canadian bankruptcy over US assets that complicates that process. So it's, that's the menu, and there's probably some more options that really call for increased creativity. And what is the right one is incredibly factually dependent, more so than I think any other industry. You have one arm tied behind your back in that you're kind of cash strapped. You have another in that bankruptcy isn't an alternative. And you've got to figure out your way through a pretty complex maze with that scenario.
And on something, then, because Eric has acted as a receiver, I'll leave receiverships to him in just a second for more detail. But back to the assignment for the benefit of creditors, and those two seem to be the most popular choices here, at least in what we've seen recently. Are there cannabis-specific ABC rules out there on a state-by-state basis, or is it just lumped in with general ABC laws or common law across the states? What's your experience been?
Yeah, it's hit or miss. So again, this is a really new industry, at least the legality of this industry. Cannabis has been around, but the legality of cannabis, I think that California legalized medical cannabis in 1996, that the first consumer or recreational cannabis laws are maybe 10 years old. There's a lot of catch up. And so it's an awkward juxtaposition between state bureaucracies and regulators, businesses that these regulators are looking at with really incredible scrutiny, perhaps more than they should. And then the federal government, which is saying this is still illegal. And so to answer your question directly, as I've danced around it, it really is a state-by-state basis. In many instances, the statutes are not great. Perhaps they mention S&E, perhaps they don't. And depending where you are and what the situation is, it's sort of a risk-reward scenario. You're figuring out, can I take this through an ABC? What are the risks? Do the statutes provide for it? What can an S&E do? Can they take ownership? Can they? And that in many instances involves me calling you to call a regulator and say, hey, we want to try this. What do you think? And no one's going to say you can definitively do it, but you can sort of get some pre-clearance that makes it a lot easier to take a path.
I think probably part of the issue is that the majority of these laws were written on the back of voter initiatives. So you had a mixture of lay people, policy folks, advocates putting together these incredibly complicated regulatory schemes. At one point, let's say back in 2012, 2013 with Colorado and Washington, solely to satisfy the Department of Justice. So they were not contemplating things like ABCs, receiverships, bankruptcy, banking, let's face it, consumer safety. They were all about essentially criminal justice avoidance with having these really tightly regulated markets. And then the flip is once the regulator gets in, starts adopting cannabis-oriented rules, and most of these regulators have come from other fields like liquor, spirits, maybe financial departments. I know, Steve mentioned Washington State. Before cannabis, the liquor board was where politicians basically went to die. And it was not a super popular agency with a lot of acumen. That's obviously changed. But then they get in there and they start rulemaking around these particular issues. Like California does have specific regulations around ABCs and receiverships that you don't see in other states. And whether or not that's appropriate is not for me to answer. But the trap is laid that it's complicated by the way these laws were written. They were meant to get voter support. They were not necessarily meant to be logical. And I think that's why we run up against some of these issues when we talk about restructuring, M&A, and dealing with a lack of bankruptcy. They just didn't contemplate those things. So I'd like to move on to Eric on the receivership side. And receivership has always been, to me, by most people, roundly misunderstood, and especially in cannabis because it is new, it is nascent. This is emerging for most of these folks. And I've had clients say to me, can't I just have a receiver appointed? And I'm saying, well, in what capacity? And they're like, a third-party referee where we go to a conference room and we sort out our assets. And I'm saying, I don't think that's how this works. Can you give us some detail around receivership and why it's so unique?
So I think when I hear how you just described that, I think I'm more of a special master than a receiver. And I have seen that appointed in cases actually as well, where there's just typically partnership dispute that they don't necessarily feel like they can't keep running the entity, but they are still feeling like there's an issue there. But essentially what receivership is you're appointing the courts to operate the entity, right? It is, in a simple term, a state version of bankruptcy that's oversimplification, and that's also very different state to state. Missouri, we have really great statutes that were developed and put in place in 2016. Since Washington first redeveloped their receivership statutes in 2002, we've had about 18 to 20 states redevelop statutes on receivership, which predates bankruptcy statutes in our country. And what that's done is it's allowed a lot more clarity to make sure that people can operate an entity and that a judge essentially can operate an entity with a known quantity. So the judge takes over in a receivership the entity or property that's being appointed into the receivership. And then the judge says, probably I don't have the time to run that entity, and I also probably don't have the experience to run that entity. So I'm going to appoint a receiver to take control on my behalf. So as a receiver, you're an arm of the court, and as such, you actually, as long as you're doing all the right things that you should be doing, you have some judicial immunity as you're operating. And your role is to come in, and in certain states, you're required basically to sell off the property. In certain states, you're actually not allowed to sell the property. And then in certain states, you have a lot of liberty to do a similar role to a Chapter 11 or a Chapter 7. So again, very dependent on where you're operating it at. We are seeing more and more states, especially after the Uniform Law Commission adopted the UCRERA, the Uniform Commercial Real Estate Receivership Act. We're seeing more and more states take on new receivership statutes, either adopting that in its original form, or now we're seeing more states coming in and saying, we like the idea, but we don't want it limited to just real estate. So let's adopt UCRERA for all operating companies. And then a few of the states that originally adopted it are even going back and saying, let's revise what we just adopted 5 years ago. So they didn't change their laws for 150 years. And within 5 years, they're changing their laws again on receiverships because they like what was put in place. They just know it's not expansive enough. And so when I come in, especially in a cannabis receivership, we're coming in really with the idea of, does this need to be restructured? Does this need to be just liquidated? Sometimes there's a clear answer because they've closed the doors and there's nothing going on there. Sometimes it's not as clear of an answer because they have maybe even something as interesting as what Steve was talking about, where there's $30 million in revenue and there is a valid operating entity there. And so it really depends. And I think what people like out of receivership is you do have a lot of flexibility in states that have done a good job with adopting the receivership statutes. You also have the other 30 to 32 states that have really not touched statutes and probably have 100 words written on it somewhere that was written in the 1800s. And everything is going to be based off of case law. And that makes it a very difficult process because you're going to go in with your case law and someone else is going to come in with theirs, and you're going to hope the judge sides with yours. And what we've seen is, especially on the lending side, if you're originating the receivership, you're able to have a much clearer outcome to what's going to happen because there are statutes in place. So I can go in as the receiver, I can go in and say, Your Honor, this is what I'd like to do, and this is the statute that gives me the right to do it. And as long as there's no objections, the judge pretty much rubber stamps that and moves it forward. And I'm sure a judge would not like to hear rubber stamped, but as long as a lot of these judges have a criminal background, or they're coming from a background that they don't understand what's necessarily happening or what's going on, or the level of detail to make real informed decisions. And so they are leaning on the receiver to make those decisions.
And just back to procedure, because this is not, at least to me, a super robust area of practice of law. It seems to be cyclical depending on how industry is doing, industry to industry. And many people just only know of bankruptcy. Does the court appoint the receiver unilaterally? Can the parties fight it? Do the parties ever agree with each other, hey, let's appoint a receiver? And then on the back of that, with a receivership, do you have to have an underlying cause of action? Meaning, do parties have to have sued each other? Does there have to have a default? Can they just go into court and file to appoint one? How does that work? I know it's very basic, but I think it's important.
Well, I hate to say it, the answer is yes, no, and everything in between, because again, it's very state specific. And so it really depends on where you're at. Certain states, you do have to file a lawsuit to originate it. Certain states, you can just file an action and bring it in front of the judge, and it doesn't actually have to be a lawsuit pending against one of the parties. What's a little bit different than bankruptcy in this case is it can cover several things. It can be a partnership dispute. So partners can bring it into court and actually say, you know, we don't agree with each other and we need a receiver put in place because I don't trust the guy across the table from me to operate the entity until I have more clarity. And oftentimes what I see, and again, my background is finance and accounting, so I'm probably a little biased, but I see that most often take place when there's not a clarity or a trust in the financial situation of the company. That people say, especially in cannabis, where there's maybe 9 or 10 different entities that have been set up operating all the different pieces, people start to say, wait, does it feel like he's getting more money than I'm getting? And there's probably a logical reason behind which entities someone is a partner in and which entities someone is not a partner in. So we have partnership disputes are a big portion of what originates a receivership. One thing that's different than bankruptcy, although you can go through an involuntary bankruptcy, but I think everyone is aware that that's a bad decision, probably 90% of the time. I don't know, maybe that's even a higher percentage than that. Secured creditors can bring someone into, or an equity holder can bring the entity into a receivership. Oftentimes that's going to come with some pushback. Oftentimes that's going to come with needing a really strong reason in front of the judge, because now you're starting to originate a court action on an entity that isn't necessarily saying they need to be in that court action. Sometimes they're going to agree to it because they know this is the only path they have. You know, if they've not made a loan payment in a year and a half, they're probably going to understand that this is coming. So to your point, then a receiver is selected and proposed, typically by the plaintiff. If then a couple scenarios can play out. Either the defendant can say, we're good with a receivership and we're good with the receiver. A defendant can say, we're good with a receivership, but we propose a different receiver. And then the judge makes a decision on which of the receivers is appointed. Certain states do seek for multiple people to be suggested, and the judge will essentially interview them to make a decision on which receiver gets appointed. And in some cases, the judge just says, I don't like your choices, or no one's been proposed. And so the judge appoints someone. I've known several people that have been appointed as receivers in a case they didn't even know existed, and just gotten a phone call, or even worse, a letter in the mail saying you've been appointed receiver in this case. That's an odd feeling to know, I guess, but it probably speaks to the quality of your work, if I'm trying to put a positive spin on it, that the judge just trusted you so much that even without asking, they appointed you receiver in the case. Rarer, but there are kind of a lot of variables in it. The other entity that could put the group into receivership that I've not seen in cannabis, but happens especially in the nonprofit world, this is really the only one who can put a nonprofit essentially into receivership, is the regulatory agencies. And it would be an interesting thought. You talked really briefly early on, there has been some quality control issues, is maybe a nice way to say it, in certain states going on over the last year or two. And technically the regulatory agency probably could come in that is in charge of cannabis in that state and say, until we know that you're doing things the right way, we're appointing a receiver in charge of this entity. Again, I've not seen that done in cannabis, but it happens in other instances, most commonly with groups like the SEC and FTC and a federal equity receivership, but also state agencies do put other groups into receivership as well.
And who bears the cost of the receiver?
So your first hope is always that it's coming from the entity itself, so that the entity has enough funds either coming in consistently or in the bank that it funds the receivership. If not, typically the plaintiff becomes responsible for funding the receivership. Now, if you have two individuals fighting and they've run the company into the ground before that, that's going to be a hard sell, and you're probably going to struggle to find a receiver that's going to say, yes, I'll do this work for you. Because, I mean, at the end of the day, you know, first rule of thumb, whether you're an attorney, whether you're a receiver, and turnaround is how am I getting paid? And so if you can't answer that question, it's probably a case you should consider walking away from, at least, or have a darn good reason why you aren't going to walk away if not. But really, the receiver can take on loans typically. Usually you would put that into your receivership appointment agreement, that you can take on a loan to fund the receivership. And so I've had it in cases, including in cannabis cases, where the partners have funded the receivership at a reasonable loan amount. Now, there will be some receivers that say with it in their appointment agreement, they don't need to publicly disclose that information. We kind of take the alternative approach of providing more information is going to keep everyone in a better position than providing less information.
And you were part of one of the first receiverships in Missouri. Did you find yourself educating the court a lot? You said the court typically leans on the receiver, especially given maybe their diverse backgrounds that don't have any familiarity with this particular industry and its ever-changing regulatory landscape. Did you find yourself educating them just a ton on what was and was not allowed under the regulations?
I have an incredible attorney in this case, and she has done a fantastic job, and that's made my life so much easier. My goal is, whenever I go into court for anything, is to not have to speak at all. So having a good attorney makes that that a really good scenario. But I would say it's really judge to judge, right? Because you're in state court. If you're going into bankruptcy court, there's only a few judges that are there. But if you're in state court, you're dealing with a different judge. Certain states, they actually do not keep the same judge per case. So you might have the same case and have a different judge every time you go in. And so you do have some judges that are really well versed in what's going on, and you have some judges that are needing that education. We sat through one appointment hearing where the defendant got up and said, if you appoint a receiver, the state says they'll take away my licenses. And, I really want to jump up and be like, that is completely false. I have a receivership in this state and know this not to be the truth. Obviously, I'm not going to jump up and scream that in court, but you do have to educate the judge then as it's your turn to talk, not just jumping up in the middle of court and yelling things out. But you do have to educate the judge on, Your Honor, here's what actually plays out in these scenarios. And what we found is the state of Missouri, I know Steve touched on it a little bit, has been great to work with. They've been very business friendly. And so it in turn has really made life easier. And I do get a scenario, though, where I probably work with educating the state on what a receivership is more than I work with educating the judge on how to operate a cannabis company. And what's going on. Where we do have to get in there is when we have to go through different filings than we might have to otherwise. But again, that's not that different than if I was trying to transfer a liquor license, right? I'd have to go through state approval processes the same way, and that's true of cannabis. And so I think there's some basis for the judge to understand, even if it's not industry specific.
Fair point. And I kind of have a twofold question, starting with you, Eric, and then I'm going to kick it back to Michael for a second. I see just shameless marketing and self-promotion around, I'm a cannabis receiver. Cannabis receivers have to have X, Y, Z and knowledge base. The lawyers do it too. It's an inevitable animal with a new industry that everyone is an expert. What actually, give me like your top 5, makes an excellent cannabis receiver? And then Michael, same question for you, but on the ABC side with the trustee assignee, because I know that's got to be relevant.
So I think it's what makes a good turnaround person in general. I think there are certain states where having that experience can be more valuable. And why I say that in cannabis specific is you do have to go through some form of approval process to operate the entity. And so if you're being appointed the receiver of a cannabis company, you probably can't just walk in the door and start operating. In every state. In certain states, there's a lot more flexibility to it. Missouri was great to work with through the process. And while I did have to have an escort initially when I was going in, while they were going through my approval process and background check, it was not a difficult process to go through. What I think you have to have, probably better than almost any other industry, is patience. You have to have understanding. Usually cannabis operations have fallen into a department in the state that in some cases, like state of Missouri, it falls under health and senior services. And so they're operating senior care facilities and cannabis operations. And now maybe there's a good correlation in there that I'm missing, but maybe the elderly are really up in smoke as the title of the panel is, but you do have to work with them on, here's what we're going through, because in Missouri, we just legalized recreational cannabis last February. And you do have to have that flexibility of change. Even on the train ride up, I got a notice of changes to policy from DHSS, and those probably come out 3 times a month. So those are little things like how you file, how you submit information on what you're in charge of, or anything you've purchased or sold. The other thing I would say is in there is knowing kind of what you're operating. So there are essentially 3 different licenses in Missouri. there's actually a few more, but the three major ones are cultivation, manufacturing, and retail. Obviously, you're going to have some different perspectives to it if you're operating a retail operation versus a cultivation or manufacturing operation. Again, I also go back to, is it continuously operating, or are you winding it down? And then you're just kind of going to have to know how to go through that wind down process more than you probably have to know how to, even as the receiver, even in an operating entity, you're not going to be the scientist that's actually improving your grow operations, right? That's not your role. Your role is to maintain the value of the business while the solution is provided.
Got it. And Michael, same question for you on the assignee trustee side. What makes an excellent candidate for that position? Because there's got to be good ones and bad ones out there, just like anything else, but for cannabis.
Yeah, I'll try to be brief. I know Brent hasn't had a chance to weigh in yet. I'll say this. It depends where you're sitting, but in any scenario, by the time you've gotten to an ABC or a receivership, you're looking at sort of two things, downside, upside. What's my upside? What's my downside? And in either scenario, you're going to say, my upside is going to be maximized and my downside, minimized by having someone sophisticated and capable. And so, I mean, we're talking about an industry that doesn't have a great deal of history. So sometimes you lean into that deep level of sophistication and creativity. But to the extent that a practitioner has some experience in cannabis, a relationship with the necessary regulators, an understanding of how the process is supposed to go. And so, look, I get that it's a unique intersection, cannabis and insolvency, but everything in insolvency is somewhat of a unique intersection. And relying heavily on, the standard assignees and receivers are going to be a mile deep in insolvency. They'll need someone who's a mile deep in cannabis to help them walk through that. And it's those assignees who understand which counsel to use, how to get through efficiently, both cost efficiently and from a regulatory perspective. And that's basically it. Otherwise, I'd echo everything Eric said.
Okay. And moving on to Brent, probably in our last 10 to 12 minutes, I want to talk about M&A in this space. And M&A, also wild, just like anything else, totally fact dependent, party dependent. Brent, you've done a ton of deals of all sizes, and I think a lot recently in the cannabis sector. When you got a client that's buying assets or equity out of a receivership, out of an ABC from a restructuring, do any of the benchmarks, hallmarks of M&A change? Because number one, it's cannabis, and two, it's at this intersection with insolvency generally.
I think you have the same standards as you do for any M&A deal, but you have like extra layers of complexity, right? Because most of the states, as you kind of alluded to earlier, when they put their laws into place, and some of them have started to update these, or they've seen where other states have kind of stumbled and have better regulations in place, like sounds like Missouri does, and Maryland has recently updated their laws. But a lot of them were put in place, their focus was on equity and controlling who was going to be the owner. We got to know who the owners are. If they thought about debt at all, it was mentioned like once or twice in the statute. And the concept of a cannabis business going out of business or having financial difficulties like didn't seem to occur to them, right? And so what happens when you hit a spot where the business is in trouble and you have lenders who are coming in and asserting that they want to get paid or they want to take ownership because they have a security interest in the assets to the extent that they can take that, right? There are limitations on what you can take. The statute, the regulators in most states then take the position of, okay, well, you're changing the owners of the company. And so you got to run through the entire equity change process with me, which is cumbersome and lengthy. I think one of the big things in this space is that everything is going to take longer than you think it should, right? Everything is going to take way longer than you think it should because you're dealing with state regulators who aren't really thinking about this type of thing. It didn't occur to them when they were putting the laws and the regulations in place. They're not really familiar with the problems that you're encountering. And you're going to have more people that you have to kind of get approvals from to get anything done. You got to talk. If you're doing a restructuring, you're trying to make the lenders, the senior lenders, and depending on the value of the business, the mezzanine or junior lenders happy, right? They all got to kind of buy into it. So that takes a while. Or you're dealing with a receiver who then maybe has to get the blessing of a judge, or you're dealing with a assignee under an ABC. And they also have their views of things, right? And so it's just a slow, cumbersome process. And then in the meantime, you've got a business that isn't doing well, right? And so it's a problem all the way around. I think that's probably the biggest takeaway, is that it's going to be way slower than anybody wants it to be. And nobody's really willing. And it's difficult for anybody, usually other than the senior lender, to justify putting any money into the business to keep it going. Because the equity is essentially looking at, I'm zeroed out. Why would I put money in? Right? The junior lender is in a similar situation. Obviously, this varies upon the value of the business, or what people think the value of the business is. And then there's another third party in there that we haven't really talked about at all in this discussion so far today, and that's landlords, right? Because most of these businesses are licensed to operate at a certain location, right? Or they're subject to like local approvals that you get to operate in this spot. Or there are restrictions on where you can operate a cannabis business. And essentially they limit you down to like, this area in the city. And so you're getting into this position where maybe you're behind on your rent payments. Probably you are, because you've been trying to make payments to people to juggle the balls. And the landlord's like, okay, well, I'm going to get caught up, right? I want my money, because where are you going to move your business to? The only way that you're going to actually be able to turn the business around and actually operate is probably in my spot, right? Especially if it's been built out, especially for like a grow or a dispensary, because you've dumped millions of dollars into it with special LED lights or all the security the state requires. The landlords are a gorilla in there that are going to demand their payment. So that's just yet another party that you got to get on board. And that's, one of the reasons why these things take much longer than you would like.
And what kind of diligence have you performed on behalf of, let's say, a lender whose borrower has defaulted, or a buyer that's coming to the table to get some cheap assets? I know it's got to be specialized in this particular space because of the distress, but also the cannabis curveballs that come from the state and the locals. So what kind of diligence have you found yourself doing?
There's the standard financial diligence, right? You got to figure out, is this thing even viable, right? That's usually not what I'm doing. It's like client is figuring that one out. But that's obviously the core. That's point number one. If it's not even viable, then you're just shutting this thing down, and we're going to either just sell the license to somebody else who can then try to get it moved into another location, or not. Then you're going to look at your state and local licenses and make sure that they're in good standing with the regulators and that they're not like planning to revoke the licenses. You're going to look at your state, in particular your state taxes, because like, for example, in California, that can be a really big issue. A lot of the state CDTFA is letting people go on payment plans. A lot of the people that are doing this don't recognize that they are putting themselves on the hook personally for that liability. The officers and directors of those companies are personally liable for those taxes that are not paid. And then when you're coming in to do the restructuring and the buyer's like, well, I'm not paying that tax, suddenly the sellers are like, whoa, right? Because they don't want to have to sell their house to pay the taxes that they deferred, and they unknowingly dug themselves this enormous hole. Federal tax is less of an issue, and going forward in the future, it's probably going to be solved. Another thing is to kind of look at the type of license that you're looking at. I mean, a lot of states have social justice licenses, and they have restrictions on those or all of the licenses and their ability to be transferred at all, right? So like New Jersey's rolling out new licenses, and some of them just have like a 2-year prohibition. Okay, so how do you deal with that? How do you transfer the economics of that? The old school way was, I'm going to put a management services agreement in place, and you continue to hold the license, but the economics are all moving over to this third party. And some of the states have figured that one out, and they put all kinds of prohibitions on MSAs now, right? Like in Nevada, you've got to get pre-approvals to enter into an MSA, and then that's a time-consuming thing. Just another layer of permission that you have to get to basically get to the end goal of moving the ownership of the business into the hands of somebody who can actually run it.
And probably last question before I kind of open it up to the floor in the 5 minutes that we have, just to kind of dish on this. What do you think the biggest curveball you've seen in this kind of M&A is, since you've worked state to state with multiple different kinds of cannabis businesses on the other side of the table?
I would guess so. It's probably a general lack of sophistication amongst a lot of people that are working in this industry, right? The cannabis industry is still like, it's a gold rush mentality, and there are a lot of people running into it, and a lot of people aren't great at running businesses, right? And that's why we're having this discussion. For up until, I don't know, 18, 24 months ago, people were just throwing money at anybody who had an idea and could get a license, right? And it didn't matter if they had any kind of operational experience anywhere in any industry at all. And that has changed dramatically, and we're in the fallout process of that.
Mm. Okay.
That's the biggest surprise to me, right? Everything else, all these other things are just hurdles that you you have to deal with. But the surprise is kind of like okay, so you don't really know exactly what you're doing.
I think that's a fair assessment. And it is truly shocking who is able to get a license in some of these states that even claim they have barriers to entry that are sophisticated. Most are not. And on the back of that, Steve, via Altmore, have you participated in these ABCs and receiverships as a lender? And how has it gone for you guys, given that it's incredibly rocky and volatile?
We have, thanks to the great expertise at Husch, Blackwell, and a couple other advisors, we were able to be successful in kind of resolving these issues. But I mean, this is really complicated stuff, right? Like, insolvency is really complicated. You add on cannabis on top of that, it becomes multiples more complicated, just because everything's very new. And without great advisors, we could not have done it. I think, as Brent mentioned, it does take much longer than anyone has ever expected. Like, a team internally, it really took twice as long as everybody anticipated. So I think one thing that I would say is pick your advisors right. I think because this is a very sensitive process, having advisors, receivers, or as who's got a nice even keel personality is probably a good way to go. And being able to find that person is not easy. So I think putting a lot of upfront time commitment to find that right team member who's going to guide you through this complicated process, I think is probably a time well spent. So that's kind of my 2 cents is really find the right team, build that right team so that you can be successful through the process.
Fair enough. And I'm going to end it because we've only got a minute, but I'm going to open it up to Michael and Eric very quickly. I'm going to ask you the same question I asked Brent. What's the biggest curveball each of you have seen very quickly with cannabis restructuring, ABCs, or receiverships?
I think to me, it really does piggyback on what Brent was saying, is that I feel like there is a little bit of the cannabros going on, where it's like, bro, let's start a cannabis company. This will be so awesome. And somehow they've managed to raise a significant amount of money to get that off the ground. And then we see buyers coming in, and I'm not even sure the buyers oftentimes understand the value of the industry and what's happening within a state. Missouri is a great example where we have a unique situation right now where we are the lowest tax rate in the country for cannabis. It's actually lower than our sales tax, which blows my mind. And we have one state next to us, Illinois, that is the highest or one of the highest in the country in sales tax. And then you have 6 border states with it recreationally illegal. And so with that, over time, sales are going to naturally drop because there won't be people driving in across state borders to purchase. And I think, I'm not sure even the buyers coming in have really processed the idea of really what impact that might have.
Okay, Michael, take us home. What's the weirdest thing you've seen that's blown your mind?
I think it's been covered. It's a mixed bag of sophistication. You have incredibly sophisticated parties like Altmore. You have other parties out there that are they just don't know what they're doing. And there's both a considerable amount of cash in the industry, but the various state and federal regulators have essentially penalized this industry, making it very expensive to survive profitably. And that's was a complete surprise to me when I started getting involved. And when I talk to people who aren't in this industry, they think, oh, cannabis is gangbusters. We see the revenue numbers. It's in the billions. What do you mean that you're busy with cannabis work? And that's just a huge surprise to them, as it was to me initially. And it's still, after all this time, just very shocking that they're kneecapping themselves for no reason. And I'm talking about the regulators.
I appreciate all of your takes, guys, and thank you very much for participating today. I think everybody's going to benefit from this conversation. And as a reminder to our audience that's still on, recording of the webcast is going to be emailed to you tomorrow. Definitely try to complete our survey. It really helps us serve you from an educational perspective. And with that, this concludes our webinar. Thanks, everybody, for your attendance and time.
Thank you.
Thank you.
Bye-bye.